gave an explanation for him not being here. I don't know if any of the accused persons are aware of his whereabouts. Can you call Mr. van Wyk 3 times outside, please?
Sorry? My apologies. No, it's not good enough to just say my apologies. Is that good enough? You have to tell me why you are late. Yes.
I went to the office of Mr. Samherji to file something. It's a document. Mr. Samherji is not around. I spoke to Mr. Mwapopi, something like that. When I went in, I was waiting for him.
And so you wait for Mr. Samherji and keep your court waiting for you. All right. You can take your seat.
As it plays a court, the second alternative to count 8, that the accused are guilty of the crime of theft has read with sections 94, 155, 156, and 332, subsection 5 of the Criminal Procedure Act 51 of 1977, in respect of the same accused as mentioned in the main count. In that, from a date more precisely unknown to the prosecution, but before and including 7 August 2014 and continuing thereafter to 27 November 2019 and beyond, at or near Windhoek in the district of Windhoek, the accused persons acting in common purpose did wrongfully and lawfully steal 50,000 metric tons of horse mackerel valued at 150 million Namibian dollars, the property of or in the lawful possession of the Minister of Fisheries and Marine Resources and or the government of the Republic of Namibia. Thus, the accused person did commit the crime of theft.
We are not normally allowed to use and or, but you've got to decide whose property it is. All I'm saying is this use of I see is quite a habit, and or. You always, I don't know if you've ever seen in a statute in the Constitution or anywhere where it's and or.
It's utilized, Your Lordship, depending on what can be proved.
All right.
As it plays a court, Your Lordship.
Yes. Alternative 2 to count 8, the charge of theft. Mr. Gustavo.
My Lord, I understand the count. I'm unable to plead in the absence of legal representation.
Are you together charged with the entity?
Apologies, my Lord. That would be for myself as well as the entity number 11. Sorry, accused 11. My apologies.
Is there any plea of not guilty? Yes, Mr. Hatuikulipi.
Yes. In respect of myself, accused 17, 18, 19, 20, and 22. A plea in terms of section 106(1)(f of the CPA, lack of jurisdiction of a court.
not guilty.
Yes, I plead 1061F for Pius 3 and 21 as I've indicated earlier.
I take it you understand the charge.
I understand them, I disagree with them, I find them nonsensical.
Yes, the plea entered this one of not guilty. Mr. Esau.
Thank you very much, Your Lordship. On this second alternative, count 8, on the merits, I'm a little bit indifferent. I don't understand the merits of this very charge, because there was no case, no judgment in fact, on the question of allocations of quotas. There is no judgment, there's no case, and I'm drawing this very issue from the judgment of this court. And I don't know why am I charged all of a sudden. And for me, just to plea on this very count, the second alternative to count 8, is that I do take into account the Namibian Constitution Article 12(1)(e), not having a legal representative, and I will plead not guilty.
But you understand the charge, do you?
I don't understand why are they charging me on this, because there was no court judgment.
No, what I'm saying is understanding the charge and objecting to it on any other ground are two different things. When we say, do you understand the charge? In other words, we simply say, you are charged with the purpose. They are saying to you, you wrongfully and unlawfully stole 50 metric tons of horse mackerel valued at 150 million, the property of the property of or in the lawful possession of the Minister of Fisheries and Marine Resources and or the government of Namibia. They are saying you stole. Yes, so do you understand that charge? What they are alleging against you?
From the face value, as it's written here, I do understand.
You understand the charge?
I do understand,
Yes.
But one thing, there's a qualification on this understanding of mine. And this qualification is the fact that there was no judgment prior to the 7th of August 2014 and continuing even after the 27th of November 2019. That says that 150,000 metric tons of horse mackerel was unlawfully steal. This is unlawfully steal. So you steal unlawfully 150,000 metric tons of horse mackerel. It is above my comprehension as a minister then to steal. I understand the charge, my lord.
Yeah, you see, the issue here, as we will get into the evidence, if we are lucky to be together, The issue is you are charged with the common purpose. That means it might not have been you who actually did it, the physical act. It might be one of you. That's why it's common purpose. You see, when you are charged with common purpose, it normally means the act of one is attributable to you in the circumstances set out. So, at the moment, as I said, what we want to know is, do you understand the charge? You deny it, you show that it's baseless, but that is a matter for the future. For the moment is, yes, I understand that they are saying I stole 50 metric tons of horse mackerel and valued at $150 million. I don't agree. I don't accept that. That's all we are concerned with at this stage.
My Lord, I plead not guilty.
Yes. Yes. Mr. Tamson Hatuikulipi.
My Lord.
Yes. You understand the charge?
Yes, I do, my Lord.
Yes, and your plea?
Not guilty. And on behalf of my entities, 12, 13, and 14.
Yes. Yes, I end a plea of not guilty. Mr. Mwatelulo. You understand the charge?
I do.
Yes, and now you plead.
I plead in terms of section 106, 1F of the CPA. And that is to say, this court does not have jurisdiction.
Yes. And for your entity?
Oh, sorry, and for the entities as well. Accused 15 and 16.
Individual accused in that one. Yes.
As it please the court.
It's count 9.
As it please the court, Your Lordship.
How many counts are we dealing with here?
In respect of which count?
No, I'm saying just how many counts altogether?
There should be 100 and, let me just, my apologies, 42. There should be 42 counts. I was thinking of the pages.
Inclusive of alternatives?
No, Your Lordship, I have not included the alternatives in counting them. But we do not have so many alternatives. Maybe they will go to 46 or something. There are not so many alternatives on the other charges.
Shall we proceed to count number 9?
As it please the court. That the accused are guilty of the crime of fraud, tax evasion, has read with the provisions of sections 94, 155, 156, and 332, subsection 5 of the Criminal Procedure Act. 51 of 1977 is amended in respect of accused 1 to 6 and 11 to 22. And whereas accused 1 to 6 and 11 to 22 were part of a syndicate that used accused 11 as a special vehicle to procure fish quotas, and whereas the Samherji group of companies and its representatives mentioned in the preceding counts, which teamed up with accused 1 to 6 and 11 to 22 in the scheme to procure fish quotas on their behalf. And whereas accused came up with a scheme that ultimately led to the fourth accused being able to allocate fish quotas to the syndicate as described in counts 5 to 8 above, LTD and accused 11 entered into a catching agreement as described in a general preamble in pursuance of the scheme. And whereas the usage fee agreed was reflected in the agreements at the sum of 500 Namibian dollars per metric ton, and whereas it was agreed that 75% of the actual fees be not disclosed but paid abroad, in that from a date more precisely unknown to the prosecution, but before and including 7 August 2019 and subsequently thereafter, and at or near Windhoek in the district of Windhoek and anywhere in Namibia and or outside Namibia. The accused persons acting in common purpose and or in conspiracy wrongfully, unlawfully, falsely, and with intent to defraud, gave out and pretended and or misrepresented to the Commissioner of Inland Revenue and or to the Minister of Finance and or the government of the Republic of Namibia that A, the usage fee as per the catching agreement through which SI Holdings Pty Ltd would exploit the fish quotas allocated to the 11th accused would only be the amount of 500 Namibian dollars per metric ton. The amount of 9,800,824 Namibian dollars declared in the tax returns was the gross income of accused 11 over the tax period 2014-2019. And did then and there, by means of the said false pretense and or failure to disclose, induce the said Commissioner of Inland Revenue to the Ministry of Finance and or the Government of the Republic of Namibia to the actual or potential prejudice as aforesaid to believe the false representations and or fault take into account the amounts in the sum of $4,121,883 US that was ultimately paid into Tundavala bank account in Dubai, and a further amount of $30,275,017.85 that was generated locally for the purposes of accused 11's income tax assessments. Whereas in truth and in fact, when the accused person so gave out and pretended as aforesaid, they well knew that they had put up a scheme in place whereby accused 2 had Tundavala Invest Limited, a company registered in the United Arab Emirates, Dubai, with registration number A045/045/14/8613 issued by government of Ras Al Khaimah Investment Authority on 27 May 2014. It was specifically incorporated to receive the 75% offshore payment in its bank account on behalf of the 1st, 6th, and 11th to 22 accused persons. The said catching agreement did not reflect all gross income earned by accused 11 during the said tax period. The Samherji group of companies and its subsidiaries would honor the invoices for offshore payments as part of the scheme to ensure their continued access to fish quotas. If they had underdeclared the local gross income of the 11th accused by a whopping sum of $30,275,017.75 as per the table below. The total revenue and tax undeclared or omitted and the tax due for each year is summarized here under. For the tax year 2015, the omitted or undeclared revenue is $4,900,947, and the tax due is $1,584,303 Namibian dollars and 20 cents. For 2016, it's $109,433, and the tax due $35,018.56. For 2017, $1,963,313.54. Tax due $628,260.33. For 2018, $9,472,885 Namibian dollars at 5 cents. Tax due $3,031,323 Namibian dollars 47 cents. And for the year 2019, $13,778,437.06.
Declared, undeclared.
Yes, undeclared, Your Lordship. On the undeclared amount of $30,275,017.75 is the sum of $9,688,005.44. Thus, the accused persons did commit the crime of fraud, tax evasion.
Yes, Mr. Gustavo.
Hello, with respect, I understand the charges. With respect to myself and the entity accused 11, and myself, I'm unable to plead, Lord, my Lord, due to lack of legal representation.
Yes, I end a plea of not guilty. Yes, Mr.
Myself, accused 17, 18, 19, 20, 22. A plea in terms of section 1061F, the Criminal Procedures Act, 1977, lack of jurisdiction.
Yes, I will end a plea of not guilty. Mr. Shanghala.
Judge, I don't understand. I understand the charge. I don't understand what I'm charged for. It says accused 1 to 6 and then 11 to 22. I just want to understand what am I charged for.
You don't understand the charge.
Yeah, I don't understand the charge because, yeah, I don't understand the charge. And more so, I don't understand that there can be accountability without responsibility. You know, can you be accountable when you're not responsible? Because if I understand it, you see, I may be totally wrong. This charge relates to an amount of apparently undeclared tax in the amount of 30 million.
9 million.
And then undeclared in the amount of 30 million. Well, the sum of 9 million in the amount of 30 million. As I understand it, tax is earned in the production of income. Somebody, an individual, entity, or person pays tax. In the recitation of this entire charge, save for where it says in respect of myself and 1 to 6, myself and accused 21 are nowhere to have earned that income in the production of income. So I'm wondering, an entity and an individual which has no, this is tax law, an entity and an individual which has no responsibility is accountable.
No, Mr. Shanghala, the way I understand the charge is that if you look at the first preamble, whereas they are saying you were part of a syndicate.
Okay,
So can I just finish?
Yes.
That one alleges you are part of a syndicate, and then if you go to page 72, they are alleging that you were acting in common purpose and in conspiracy with intent to defraud, etc., etc. So the allegation arises from being part of a syndicate and acting in common purpose. That is a common criminal enterprise. That's
syndicate and conspiracies is one thing.
Well, if you are part of a syndicate, I'm sure you can conspire to do what you are doing.
Yes,
but the essence of the charge is you are not being charged that Mr. Shanghala himself did this alone. You are being charged as part of a syndicate where people sit down, they plan, they act together.
You don't have to be involved in that one, as long as it's part of the syndicate. That is how I understand.
You know, when people are charged with common purpose, which you might have to look at, basically the act of one is attributed to others because you have come together to say we want to achieve this criminal enterprise.
Yes.
So that is my understanding of the charge. And the whole thing is not to say that you did it or you didn't do it. And as I was saying earlier, that point will come to it. If you were not part of the syndicate as alleged, we are not part of the common criminal enterprise, we are not part of the common purpose, all that will be established. But the allegation by the state is what they are asserting.
Yeah, no, why I don't understand it is because I understand terms to mean certain things. So, for example, syndicate means what it means, common purpose means what it means, and then the other one you mentioned was syndicate, common purpose, conspiracy to mean something else. Now, as I understand tax, it's earned by an individual, an entity. There must be, should be received, the taxable must be receivable at the hand. So what we are saying is, here is a syndicate which morphs into a common purpose, which morphs into a conspiracy, okay? The different things notwithstanding.
You see, the syndicate, if you look at where they talk of the syndicate,
yeah,
that you were part of a syndicate, that's the allegation.
Yes, yes.
That used accused number 11, the company.
The syndicate.
The syndicate. All those who were in the syndicate used accused number 11, that is the company, as a special vehicle to procure fish quotas.
Yes. And then apparently, in the next one they say, the Samherji group of companies were used in a scheme by those accused people. And then, in the next one they say...
They say they teamed up.
Yeah, they teamed up, okay? Mm-hmm. Well, first, in the one it used, it's accused 11, teamed up with Samherji. That scheme is apparently as described above. And then at the last paragraph down there, they said, whereas Asia Holdings and accused 11 entered into that agreement, and whereas a usage fee was reflected at 500 metric ton, and whereas 75 is not disclosed but paid abroad. Okay, that's now where the preambular part ends now. It's totally confusing, Judge, because as I said, once you start and we'll get the understanding, you don't, see, first understanding tax law, understanding what happens is a practice in the fishing industry, this issue of the 75 and the whatever, let alone the facts, Judge, let alone the facts, just the concept, it's something that my wavelength is not there yet. So I'm asking myself, which tax number is the one that did not pay, for which I am also now part of the accountability for that tax number? I don't know. Is it accused 11? Is it Asia? It's not so clear for me. So these monies are then spoken about, monies which are in another jurisdiction, Ras Al Khaimah or whatever this is. No, Ras Al Khaimah is just where it was put up, but it's apparently Tundavala. 4.2 million.
Sorry, can we give the prosecutor the chance just to explain in layman terms so that you can clearly understand what the basic allegation is?
Don't forget when he answers, my question is whether it's now part of a scheme or conspiracy or whatever, what is the issue that is not done? And by which individual? So that we know that it's committed by this individual, but because it's part of the scheme, it's for everybody. It's not so clear to me.
Yeah, that would normally come out in the respective roles when evidence is laid, who did what. But anyway, let me try to explain in layman terms, please, Mr. Mwatelulo. Just the essence of the charge, what it is alleged they did.
As it pleases the court, Your Lordship, in short, I think just to sum up the essence of the charge is that there were fraudulent misrepresentation to the Minister of Finance and the persons listed thereafter. Okay. Yes, that there were fraudulent misrepresentations, although it primarily relates to accused 11 who received, it's a company, Namgoma Pescas, that received this income and was supposed to declare the tax, that 30 million in Namibia and the $4 million US, more than 4 million outside Namibia. The accused persons are charged with common purpose. And we are going to lead evidence to show the involvement of each accused person resulting in Namgoma Pescas, Namibia, failing to declare the full amount in Namibia. Because we are going to illustrate to the court that the accused persons had a discussion with regard to the 75% that had to be paid abroad. So each of them acted together with regard to how much is going to be declared in Namibia. So that is the instance of the scheme, that they were all involved one way or another. But evidence at the end of the day will be laid. I don't want to go into details regarding all the allegations, but that is the instance of the common purpose, that the other co-accused persons were involved in this matter, even though it is Namgoma Pescas which had to declare certain income that was earned in Namibia. The other accused persons had a say in how much had to be declared in Namibia, Your Lordship.
I understand. We are trying to make him understand to ensure he understands.
As it plays the court, Your Lordship, I cannot simplify it more than that. That is as simple as it gets.
What I understood him to say is, accused 11 was liable to pay tax. But because of a discussion which apparently accused persons had, or some of them had, it was designed that only a certain amount be received by accused 11 in Namibia, and then accused 11 received monies elsewhere. That's the 4 million that he talked about. And he will lead evidence to show that that money was taxable here. That is how I understand it. If that is how I understand it, am I correct, Judge, if that is correct? I just wanted to be sure, because the terminology is thrown left and right, and when you use terminology, it has meanings, and if you don't know the meaning, those of us who know the meaning get confused.
I think you're about almost, yeah, about there.
Yeah.
The whole point is the person who did not make proper returns is accused number 11, isn't it?
That is, I think, that's
right.
What I say.
Right. If I am correct, if I am not correct, the state can further explain. But for accused number 11 to come to do what it did, there was this whole syndicate involving all the accused people planning how to ensure that you charge so much is paid there, so much it goes to the company, what is hidden, I mean what is not given to the company, some of it goes to outside the country. It was a plan, that's their allegation, of a number of people
then it was earned elsewhere there and deprives here the receiver of revenue to...
No, he had the, according to this charge, he had the correct amount of the, where it was income.
Yes.
Had it been handed over to the taxpayer, would have declared the correct amount.
Yes. Okay. No, Judge, now my understanding is similar to yours. It means there was income, it was not properly declared.
We can, the only point, Mr. Shanghala, is if you understand what they are saying, the question is you understand, you give whatever defense, whether it makes sense or it doesn't make sense, and so on at the appropriate time. Here now is just like a person who is told, you stole my $100.
But I must ask first, $100, what are you talking about?
No, when you can ask that at a later stage, but when we are reading out a charge, we simply want to know, do you understand that you are alleged to have stolen $100 from this place? And you say, I understand, because you understand. And then the next thing, when we come to leading evidence, is to prove that you did it. But the allegation itself is either understood or not understood. If you are told you stole $100, it's very difficult for you to say to me, I don't understand what he's saying. It's another thing to deal with the evidence tending to show, to prove the allegation, quite apart from merely understanding what the allegation is.
Judge, you must take me the way you find me. I am a person of some skill. If I am a mechanic and you tell me the winch is the crankshaft, I will say, sorry, what are you talking about? Because the winch and the crankshaft cannot be the same thing. So, when you say, and now I understand fully, I understand now that they don't understand what they are talking about. Because as you rightly said, yes.
That we can,
yes.
You can prove later.
Yes, and that I'll deal with later, but I first wanted to understand that my understanding is that they don't understand what the hell they're talking about. And we've now agreed they don't understand the hell what they're talking about. They're saying, these people here, the ones who drafted this one, in actual fact, it is ascribed to Martha Olivia Ekanje Marwa. This one does not know what she's talking about. Because she's saying that there was income, etc. Now I understand it, I can plead to it.
Yes.
I can plead to this confusion here that one, the court doesn't have jurisdiction, that issue is still pending, 1061F. But I understand the charge as confusing and, yeah, as it is. We'll deal with this one. Yeah. It's a simple thing. If money is earned, then there's the issue of liability. If it was not earned, there's no liability by the individual.
It seems to me,
yeah.
You may escape this charge.
Excuse me, Judge?
I'm saying it seems to me you may escape this charge if you are correct.
You know, Judge, what I was thinking more.
What we are saying, Mr. Shanghala.
No, I hear what you are saying, but what I'm thinking more.
No, please. We are at plea taking. I want to know, you understand the charge, how do you plead? As to how you go around it, how you defeat them, these people who don't know what they are doing, that time will come. And you will be, if your argument succeeds, you walk home free.
No, that's fine, Judge, but what you must grant me is the ability to understand the confusion. Whether or not it's correct or not, you're right, I'll deal with it. But just, I need to understand what it is they're saying.
I now understand.
Now I understand. I was just making a comment to your last remark. It's a quick to your last remark because I must understand. As I said, if you say it's a crankshaft, is a spanner, it cannot work. The mechanic will tell you, what the hell are you talking about? So I'm asking myself, what in the world are these people talking about? Now we understand that they don't know what they're talking about. We'll deal with that when we come to that. It's a simple thing.
I enter a plea of not guilty for you and which you represent, isn't it? Sorry, is there, Mr. Shanghala, are you representing any entity in this one?
Judge, I indicated from the very beginning, on behalf of myself, accused 3 and 21.
Okay. Right. Mr. Esau.
My Lord, I'm also confused with this very indictment, that I am charged in my personal capacity for taxes omitted by an entity called accused number 11. And then on the basis of common purpose of a syndicate in the allocations of fish quotas. Me as a regulator then, a minister of cabinet, allocating fishing quotas to a syndicate. That syndicate must have met somewhere, somehow. Especially this very, not the operating paragraph, but this preamble of this kind of a resolution, which we call an indictment. That is confusing me, because quotas are not just allocated out over the counter. You don't allocate a quota as a minister who is accountable and who is supposed to be transparent with the allocations of quotas.
Mr. Esau, again, just to...
So the merits is the issue.
So, to just make you understand, these are not proven allegations. You see, what the state is saying, you are part of a syndicate. You grouped with others, planned how you best can make sure that things move the way they allege. That's what they are alleging. That whether you did it or not, that is another point. But the allegation is you and some other guys came together, conspired as a syndicate, planned, used this Namgoma company as a vehicle for you to do what they allege. So it's not like we are saying at this stage you did it. No, if you can show that this is a lot of rubbish, it never happens that way. Of course, you will show that. But for the moment, we are just dealing with the allegation, where someone is said to have done something. The person says, I didn't do it or I did it. And then those who say you did it will prove their case beyond a reasonable doubt.
Let them bring their witnesses and
Yes.
come and prove that one. Because, number one, I was a taxpayer, and I'm still a taxpayer of this Republic of Namibia, and I want to give even my income tax number if they need to know. But they know it already.
But do you understand the charges which they are making?
I understand it. It's so malicious and it's so outrageous. And I want to repeat that. Malicious, outrageous. There is a hidden agenda behind this very charges. And we will expose it when it comes to the trial, to that time when we have to. But notwithstanding, again, notwithstanding Article 12(1)(e) of our supreme law of our country, not having a legal representation, I will quote, I'm pleading not guilty.
So I will enter a plea of not guilty.
Correct, my lord.
Yes, then we come to accused number 5, who is Mr. Hatuikulipi.
Yes, my lord. do, my lord.
Yes, and your plea?
Not guilty, my lord.
Sorry?
Not guilty. And on behalf of my entities, 12, 13, and 14.
Yes, I enter a plea of not guilty. Then we have number Mr. Mwatelulo. Mr. Mwatelulo? Yes, understand the charge?
I do.
Yes, plea?
Plea in terms of section 106(1)(f) of the Criminal Procedures Act, and that is to say that this court does not have jurisdiction, and the plea stands as for accused 15 and 16.
Yes, as I've mentioned before, in those seconds, I enter a plea of not guilty.
As it pleases the court. Alternative to count 9, that the accused are guilty of the crime of contravening section 65, subsection 1A, read with the provisions of section 12, subsection 1, section 15, subsection 1, section 25A, sections 55, 56, 59, 60, 69, sorry, my apologies, 65, 66, 83, 87, and 97 of the Income Tax Act 24 of 1981 is amended, and sections 94 and 332, subsection 5 of the Criminal Procedure Act 51 of 1977 has amended, failure to furnish tax returns in respect of the same accused persons, in that from a date more precisely unknown to the prosecution, but before and including the 7th of August 2014, continuing thereafter at or near Windhoek in the district of Windhoek, the accused persons acting in common purpose did wrongfully and lawfully failed to submit income tax returns in respect of income earned by 11th accused, which was diverted to the offshore account, to wit, Tundavala Invest Limited bank account in Dubai in the amount of $4,121,883 US dollars. As it pleases the court.
Sorry, can you just go over it again? The charge is against you, all the accused as in the previous.
Yes, Your Lordship, as in the main count.
And the charge is failure to do what?
To furnish returns for tax in respect of the amount of money that was transferred to a company, Tundavala Invest Limited.
Yes. And the allegation again is that they acted in common purpose to procure that result.
Yes, Your Lordship.
Yes, the alternative to count 1, Mr. Gustavo.
My Lord, in respect of myself being the first accused and accused 11, I'm unable to tender a plea lacking legal representation.
As discussed before, in those circumstances, I enter a plea of not guilty for you and the entity. Mr. Hatuikulipi.
Yes, in terms of, in respect of myself, accused 17, 18, 19, 20, and 22nd, we plea in terms of section 106(1)(f).
Yes, it's not a, I will enter a not guilty plea. Yes. Mr. Shanghala.
Section 1061.
That's for you and your entity.
Yes.
Yes, I end a plea of not guilty. And Mr. Esau.
My Lord, once more, maybe in a very brief general preamble, I rebut this very indictment. I dispute what is alleged here. And I will plead notwithstanding Article 12, 1E of our supreme law, the Constitution of the Republic of Namibia, not having a legal representation, and I will plead not guilty on this narrative or this stories, childish stories here.
Yes, I end a plea of not guilty.
Not guilty.
Yes, Tamson.
Yes, my Lord.
Yes. You understand the judge, of course.
Yes, I do, my Lord.
And your plea?
Not guilty. On behalf of my entities, 12, 13, and 14.
Mr. Mwatelulo.
Yes, Judge.
Yes, you understand the judge.
I do. I plead in terms of section 106, 1F. There is, this court does not have jurisdiction. And I plead the same for accused 15 and 16.
Yes, I end a plea of not guilty. Yes, Mr. That's the end of the 6th. You know, if you are tendering a plea like before, if you think it saves time, you can just say, I stand by my pleas in respect of count. I'm talking to you. I'm talking to everybody. That if you are tendering the same plea, it is sufficient to say, well, I tender a plea like I tendered in respect of count 5. If it is the same, we'll quicken but the whole point is, of course, I will want to understand, to know that you understand the charge. Then you say what you say. Right, so that's the alternative to count 9.
Yes, Your Lordship. Count 10.
Count 10.
That the accused are guilty of the crime of fraud, tax evasion, has read with the provisions of sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977 as amended, in respect of accused 1 to 6, whereas at all given times the accused were registered taxpayers, and whereas the accused did not declare their full income generated from their participation in the fish quota scheme as described in the general preamble, in that from a date more precisely unknown to the prosecution but before and including 7 August 2019 and subsequently thereafter, Your Lordship will just request to delete the second subsequently thereafter. It was repeated. and at or near Windhoek in the district of Windhoek and or anywhere in Namibia and or outside Namibia, the accused persons individually did wrongfully, unlawfully, falsely with intent to defraud, gave out and pretended and or misrepresented to the Commissioner of Inland Revenue and or the Minister of Finance and or the Government of the Republic of Namibia by failing to declare their full gross income for the tax period 2014, 2015, 2016, 2017, 2018, and 2019 for purposes of their income tax assessments and indicated below. A, accused one, Mr. Ricardo Gustavo, the ID number and income tax number is reflected on the indictment. Your Lordship, I don't think there's a need to read this into the record. Yeah.
Depends on them, but you may, if there is no objection, just say the total accumulated tax due by each of them is so much as per the table.
As it plays a court.
Unless one wants it to be read.
As it plays a court, Your Lordship. If they don't object to that, we can read it in that manner, Your Lordship.
I just want to understand, to read the tax number and then the tax details. My Lord, I believe, these tax issues are personal and things are being ventilated in court. I'm not sure that it's, I don't know, I'm not speaking for everybody, but at least from my understanding, I'm not sure that it's correct to reflect those in open court publicly.
Yes, that's what I had indicated, Your Lordship. We wanted confirmation from them that we can skip this. There's no need to read it. It's available.
But he's saying something different.
I know, Your Lordship, with regard to confidentiality, but the end result is the same, that we don't need to read the text number and the ID number. I don't think there's an issue, but they must indicate if there's an issue with not reading the other details, as the court suggested.
Let's deal with one point at a time. What is his objection?
To reading the tax numbers and their ID numbers. He says this is a point of litigation before another court. He does not want these details in the public view. The only reason...
I still don't understand the objection. He's charged with an offense, isn't it?
Yes, Your Lordship.
Details of which are here in the charge sheet.
Yes, Your Lordship.
The objection is to what, insofar as confidentiality and things, is what?
No, we can read it. It's not.
No, I'm saying I want to understand his objection first. If you understood what he is objecting to.
All right. I think you can clarify to the court, then I'll respond, Your Lordship.
Because all I was saying, in reading the charge, for convenience, you can read throughout all those tables if you want, but you can also say as per the table at page so-and-so, and with the total accumulated tax due of so much.
Yes, Your Lordship. Right. I think that is the issue he did not touch on. He only touched on the issue of identification and the tax numbers. So those are the ones he did not want to read. But he did not touch on that suggestion that we do not read the entire box. He has not. His
objection is that his ID number and income tax number shouldn't be mentioned.
They are confidential. He prefers for them not to read them. But we also.
It's not about preference. You are charged, and those are the details.
Yes,
to give the details as to how the charge is arrived at, isn't it?
Yes, Your Lordship.
And the objection is to say don't mention them.
In instance, what I was informing the court is that it's before the court, the indictment is before the court. If they accept the details as correct as they are, perhaps just for security reasons, we know fraud sometimes can be committed with PSN's ID numbers.
You see, let's understand what Mr. Gustavo's objection is. The point here was, do you want him to go reading through the tables so that when he, for instance, mentions you as accused number one, he mentions your ID number, your income tax number, he skips and says there's a table there showing the details and there is a total amount undeclared income of so much. That was the question, whether I need him to go through the table or not.
Yeah, no, I think, my Lord, it just goes to follow that if I was objecting to the ID numbers, the income tax number, and then it just goes to follow that obviously the data that's related to that in the tables.
Can I be clear? You're objecting to what?
I have no issue with him referring to the table as it is in the indictment. It's the reading out of that information that I'm taking issue with.
The reading out of that information.
Yeah. I have no issue with him saying, look, in respect of Ricardo Gustavo, accused number 1, ID number is reflected, income tax number is reflected, and then the table as reflected in the indictment. I have no issue with that. But my issue is going in and saying, okay, now we continue Ricardo Gustavo, accused number 1, ID number so and so and so, born 1967, income tax number whatever, the total revenue, tax years, this, that, and the other. That's what I'm taking issue with.
You say that should not be done in court.
Well, yes, I'm saying that that's. I have no issue with him saying, look, the table is there. Everybody's got a copy of the indictment, and that is what's before court.
Well, I'm not sure I understand what you are objecting to. But if it is objecting to details relating to you and the allegations made, I'm not very sure that it would be something that should be kept confidential in a court of law.
Perhaps let me ask you, what is the court's position on the confidentiality of tax information?
I don't know. I can be advised. I can be advised. But what I know is if you are charged with an offense, as much detail as possible.
There's case law on it. There's case law on it.
Yes. Judge.
Just a minute.
Yeah.
Your turn will come. Looking at the details here, because we have them in court, isn't it? Without reading them. What details do you not want disclosed?
My Lord, I don't know how much clearer I could be. I'm saying that there are personal details here, tax number, ID number, and then on page 76 onwards, there's a table that attributes, there's a table that the state has put there that attributes your at least sets out your omitted undeclared tax revenue, tax undeclared tax revenue, etc. I'm saying that forms part of the confidentiality of my tax position.
And so?
And so why must it be put out in the public? And that's why I'm asking, what is the court's position on the confidentiality of tax, the individual tax, or well, tax for that matter?
Yeah. As I will try to assist Mr. Gustavo.
Yes.
You are the one making your point, isn't it?
Yes.
Your point is to say, like it is now, there are tax details about you and the details relating to omitted declarations and the amounts of tax you should have paid, isn't it? There are details there in the charge. Yeah, they may be wrong, whatever, we'll come to that. But those details are there. Now, you don't want what to be disclosed? Your tax number, your name, what is it you don't want to be disclosed?
I'll go through it again, man.
Yeah?
I'll go through it again. It's futile not to declare my tax number, but then say, this is the number, this is the undeclared amount.
Yeah.
One goes with the other, isn't it? They're saying, Ricardo Gustavo, born in 1967, who has an income number 00 what, has underdeclared X amount. All of those go together.
Yeah.
That's my point.
So you have no objection really, except...
No. My objection is for him to read out all of that here. With him saying, look, we have Ricardo Gustavo, there's a tax number here, what, as reflected in the in the indictment, I can accept that.
So which one don't you want read out? Is it the table or what?
The table, my ID number.
Your what?
My ID number and my income tax number. Why can we not just consider it as read?
There must be a good reason why certain things must not be disclosed. you are entitled to a hearing in public. He doesn't want his details disclosed. Is there anything else you want to say about that?
There's preservation of secrecy in the Income Tax Act. Why can that not be preserved? Why can that not be preserved?
What does it say? And does it extend to a person charged with tax fraud or tax? Does it cover a person charged with fraud or tax evasion? Unless
I don't think that this was going to be a truth-pulling exercise, my lord, but it's fine. This is a pretty long section, so if you want to give me the time,
you are making the submission. My question is simply: does it cover disclosure of a person charged with fraud? And
you're going to have to give me time to just digest, read this, and then come back to you.
Yeah, but if you make submissions which you can't immediately substantiate, it's seriously.
No, that's unfair. My lord, I'm unrepresented.
You are not, but you make the point.
That's what I keep saying.
Right. You make the point.
I'm saying to you, and I keep saying this to you, my lord, that I'm not able to tender a plea because of what? Because I'm not represented. You are putting me under the spot here, saying, tell me now what that says. I'm saying, give me time, let me digest.
All right. I'm not going into an argument with you.
Neither am I, but I'm saying,
all right.
give me time to digest this.
Shall you stop?
Just give me some time to digest
this. Shall you stop for the moment? Shall you stop?
Sure.
Right. The point is this. You make the submission that these matters must not be disclosed. And I say in terms of what? You say in terms of the Income Tax Act. And I say, does it cover a person charged with the fraud and tax evasion? Does it say that a person charged with tax evasion and fraud should not have his details disclosed? If it says so, and that is my question, if it says so, just read it to me.
Let me ask the prosecution what their position is on that.
You ask them. You ask them.
What is the prosecution's position on that?
Well, I will come to the prosecution. I conduct the proceedings here. Are you able to show me?
Going to an argy-bargy about this.
Right. Are you able to show me a section which says that where a person is charged with tax?
I don't know.
All right. If you don't know, then we can proceed.
I'm not a lawyer. All I'm saying is,
right. Let me.
There's section 4 that provides secrecy for my tax details. All I was asking is, if you're saying no, I'm ignoring that.
I'm not saying no. I simply ask a question. I don't know why it is difficult to answer a question. My question is simply say, does the law say that the tax details of a person charged with fraud and tax evasion should not be disclosed? They must be kept secret. Is that what the law says?
And my answer was, give me time to go through this section.
Until when?
Lengthy section.
Until when?
Until I'm ready to give you an answer.
All right. Let's hear from the state. You wanted to know the state might have a ready answer. Mr. Yes?
Your Lordship, I think he'll need to bring a substantive application, but what I know for the preservation of secrecy under the Act, I know it's not prohibited for that information to be provided to law enforcement officers. So I believe it also extends to it being provided to the courts. If he wants to bring an application on that basis, he has not moved an application as yet. We can then deal with that application, Your Lordship. I'm just looking at the...
I don't think we should talk of him. He's just making a point, like he says he's a layman. That I wish my details of my I don't know, the amounts omitted and so on. But you see, the charge consists of a certain amount of information, isn't it?
Yes, Your Lordship.
For you to know what charge you are facing, you must be given as full information as possible, yes, so that you are told, because you can even start off by saying that ID number is not mine. So already they are off the mark. That income tax number is not mine. You are already off the mark, you see? So the judge must disclose what the allegation against you is. If there is a basis for saying, please, let's keep this confidential, then I will do so. But if there is no legal basis for doing that, we know you're dealing with some kind of cases. If you are dealing with a rape case involving a minor, you have to keep things to protect the minor's name. There are certain areas where the law requires that confidentiality be kept, and there are other areas where it's not required.
Indeed, Your Lordship. Insofar as this charge is concerned, the amounts included there, they are part and parcel of the charge.
Yes.
So in actual fact, they should be read. The only reason as to why I raised the issue of if he admits that the information is correct, for us not to go through everything, including his ID number, we're just concerned that people commit fraud with others' ID numbers. So that is why I had asked if they accept the information as correct. Perhaps then there's no need to really read the ID numbers and the income tax number.
Yeah.
We can
To shorten the proceedings, it's
Yes.
not only him, it's in respect of others. Isn't
Yes.
it? If you want us to go through, like, I don't remember, Mr. Esau is part of this, isn't he? Of
Yes,
this
Your
charge.
Worship, he is.
Mr. Esau said, I want everything read. You see? So Mr. Esau says, I want everything read. And I'm quite happy to do that. Others are saying, as far as I'm concerned, you can omit certain things. Now, I've got to strike a proper balance here. If one accused says, I want everything read, we'll read everything. If you had discussed and seen how you shorten this plea taking, I would be quite happy. But if one insists that I want everything read to me, I have to be procedural and ensure that everything is read out.
We have not discussed this issue, but I was wondering if the other accused persons don't mind that they accept all the information is correct, as indicated on the table, then we can just read the conclusion, which is indicated under the table. When you get to Mr. Esau, I can read everything, if you so wishes.
Do you see how repetitive it will be? You deal with others, they say don't read. Then when it comes to Mr. Esau, you read everything.
Just in respect of this count, Your Lordship, because they are all appearing under the count. They have their respective
No,
tables.
but they are charged with what here?
They are charged individually, Your Lordship.
Individually.
Yes, Your Lordship. That's why I was suggesting, perhaps if we get
But I don't want to be misunderstood to be saying that the details there should not be disclosed.
Yes, no.
If it is an arrangement that, well, to quicken the proceedings, we can do that. But if it is a matter of saying those details must not be disclosed, they will be disclosed. Even in a judgment, they will be disclosed.
It's certainly, Your Lordship.
So without, as long as you proceed on the basis that is your understanding, that no, it's not necessary to give all the details, that's fine with me. But not on the understanding that this must be kept away from public disclosure.
No, not at all, Your Lordship. But I do not know what the position is with regard to the...
All right, let me put it this way. What is the time now?
It's 27 to 4, Your Lordship.
Right. You said we normally adjourn at 4.
Yes, Your Lordship.
I will give you another opportunity. The parties. If there is a way in which you can curtail the plea-taking proceedings, I'm quite happy to go along with whatever you agree. I'm also quite happy, and it's part of my job, to go through reading everything to the very end. So if there is a way in which you can curtail the plea-taking proceedings, I can give you the 27 minutes to 4 to discuss that, and tomorrow we resume.
We'd appreciate that, Your Lordship. I
Yes.
think we can do that. Let's see with the other
I mean, there is a bit of unnecessary repetition, explanation, and so on. So if there is a way in which you can, proceedings are always better curtailed.
Yes.
So we can sit here for years, but if there are ways in which we can curtail the proceedings by reaching common ground on some areas, that we do. So in the minutes that remain, I will expect you to have agreed on something. I intend to adjourn And we start with count 10 tomorrow. Yes, Mr. Shanghala.
Apologies, Judge. May I, myself and my co-applicants be excused on the 17th because there's a court order requiring us to present our case before Justice Mwatelulo in the matter that relates to the appropriateness and constitutionality of this cage in this courtroom. Either or doesn't make a difference.
17th is when?
That is Tuesday next week.
All right, we'll see.
Well,
We'll consider that. We'll consider that on Monday. You never know what can happen. There may be other reasons why you are not going to court. Something may happen, judge will tell him, I tell you, no, guys, we are not meeting. So I have no problem. If you have a prior engagement, I'll be quite happy to let you go, depending if it is taking the whole morning or a whole day.
He's indicated that we should be ready for arguments because he wants to complete, even though the calendar is closed, he would set aside that day and possibly the day next, but that we should complete. But as it pleases the court.
Yes, we will get there on Monday. So we adjourn to tomorrow at 10 o'clock. The court adjourns.